So, hi everyone. We just tuned in live with Council Bar. My name is Amani, and I'm a qualified advocate and legal consultant here in Cyprus. I hope that everyone can hear me fine. So today we're going to do things a little bit differently. I'm not going to offer any presentation. It's just going to be my face talking to you, trying to build a connection and try to explain things as understandable as possible. So today we're going to discuss real estate and property law here in Cyprus. It's actually a very important topic for the local market. So this is how we're going to do the actual live presentation today. So first I'm going to introduce myself, give a little bit of a background. Then I'm going to discuss a little bit of the history of Cyprus. And then I'm going to delve into the real estate market here in Cyprus. Then I'm going to go into property law and any contractual implications as a result of COVID-19. So as I've mentioned, I'm an advocate here in Cyprus. I'm trilingual in English, Arabic, and Greek, given that I've migrated with my family here in Cyprus in the early 90s. We've been living here ever since, and we actually love it. It's not just a country with the sunny weather and amazing food, but in general, it's a very developed country that always bounces back no matter what happens. So Cyprus actually was an ex-British colony, and in 1960 it gained its independence. So ever since 1960, Cyprus has been an independent republic, and then in 2004 became an EU member. And it's actually a gateway between Europe, Asia, Middle East. So it's a little tiny island with a population of about 900,000. And it has a very, very strong economy accordingly with its given size. And then afterwards, in 2008, Cyprus adopted the EU currency. And it actually was listed in 2016 by the International Monetary Fund as the 31st advanced economy in the world. So it's really impressive, actually. And I would recommend anyone who is interested in the sunny weather and the tourism side to have a look online and just type in Cyprus, and you'll get a bit of an understanding of the background. So in terms of the economy, since the 1980s, 90s, Cyprus shifted toward a service sector. So what that means is that it focused on the tertiary industry. So it offers financial services, tourism, etc. And currently, the current state of things, the economy of Cyprus, it predominantly relies on not only the tourism sector and the financial sector, but we have two emerging markets. The one is the foreign investment, which has started really, not that recently, but like a couple of years ago. It became very, very prominent in Cyprus, and it contributed a large proportion of its GDP from foreign investment. And the second is the discovery of natural gas here in Cyprus. It opened a new market for people, basically. So if we look at the numbers, 80% of GDP is accounted from the tourism and the foreign investment sector and the employment of Cyprus. So if you understand the context of why we're discussing real estate and property law today, in light of COVID-19, you can understand that COVID-19 has actually affected not just the entire supply chain, but all the way to actual employees. So given that Cyprus really relies on those services, you can understand that it just put a sort of a stick in the wheel of economic growth. But I believe that it's temporary. The president announced about 2 days ago that he will start releasing the restrictive measures with the 4th stage. So we'll start from 4th of May next week, all the way to the beginning of July, June, depending on the actual containment measures. If we have any spur or spike in coronavirus cases, then the government will reassess the position. Okay, so in terms of economic growth, if a lot of you don't know, Cyprus went through a really bad crisis in 2013, economic crisis. A lot of people lost their jobs, a lot of people lost their money. And the thing is, what happened at the time, the president of the republic found that if he attracted foreign investment, it would be a big boom for the economy. And that was actually evident. It's evident in the numbers. Once the president, as we'll get to see in a bit, I will discuss it, he introduced basically a passport scheme. So you get to acquire the Cyprus citizenship if you fulfill a couple of economic criteria. And that allowed it to regain its investment status, and at the same time increase its GDP and allow it to become one of the developed countries in the world. Like I said, Cyprus is really small. You can understand it's 900,000 people in the island. In terms of advantages, for Cyprus is that it's not only a small economy, but it's a free market economy, and it's quite adaptable to circumstances. So not only that, its geographical positioning allows it to be a very, very strong business gateway, like I mentioned earlier, not just to Europe, but Africa, Asia, and the Middle East. And Cyprus has been known throughout its periods of history that we have a lot of people from throughout the world visiting, because it's actually in the middle of the shipping center. So we're a multinational and a cosmopolitan city. We have people from all over the world moving here, living here, doing business here. People take advantage of low taxes and low cost of actually incorporating your business here and finding appropriate commercial as well as residential properties. And it actually has a network of about over 60 countries, tax treaties with 60 countries. So that's another positive thing. And now what are we going to discuss? We're going to discuss 6 of the main economic activities in Cyprus that contribute to its growth, GDP growth. So the first is investment. Investment in that there's a couple of schemes that allow foreign investors, so non-EU and non-Cypriot, to inject a certain amount of money and acquire the Cypriot citizenship. And I'll get to the details of that in a bit. The second is, like I mentioned, the passport investment scheme. The reason why it's so attractive is that it's quite of a fast track scheme, and a lot of people manage to get the passport within about 6 to 8 months maximum. The third sector of the economy is the maritime. We have a very strong maritime sector in the economy. We have a large fleet. We have a lot of people use Cyprus flags for their shipping industry. It's a really good place if anyone's interested in the maritime sector. In terms of the tourism sector, it actually contributes 13% to the country's GDP. Cyprus is well known around the world for its sunny beaches and affordable prices. Okay, there has been a little bit of a spike with the residential properties here in Limassol, but in general, Cyprus is quite affordable for any family that's wishing to come here and just spend, their vacations here. And the final, but not least, is the real estate and construction industry, and the fact that people are starting to invest to acquire immovable property for their passport. It in turn allowed a lot of new businesses to increase. So we have a lot of, not just old construction companies, we have new people, new businesses open up to tailor to that new demand. So the reason why I mention all these things is that it's really important to understand the backdrop. Not only is this like a human tragedy, which is affecting everyone worldwide, but as well, the economic growth has been, stagnant for a while, for the couple of past months. Cyprus may have lost about 1.6 billion due to the fact that the travel bans and the movement restrictions stopping foreigners from being able to come in. And this in turn created various legal and commercial, relationships to be put to the test. And I have to mention a little bit of the numbers. So the coronavirus numbers here in Cyprus is not as bad as our counterparts, but accordingly to our population, it is, it's still a big number. So we have just below 900 confirmed cases of coronavirus. We also have about 150 cases that were recovered, patients that recovered from the coronavirus. And unfortunately, we have about 17 deaths here in Cyprus. Given the fact that it's not as bad as other parts of the world, it's evident in the fact that the government has proven to be successful in the restrictive measures that were in place until to date. So the travel bans were enforced from March. So no incoming flights. There were a few exceptions in terms of, Cypriot and EU residents. And as for local movement restrictions, people, residents of Cyprus could no longer, in general, anybody could no longer move as freely as they wished. They would either have to seek special permission for leaving the house by sending a text message, so to a governmental-based text messaging service. And essential workers were allowed to work, but non-essential workers had to stay home. So there was a complete and full national lockdown in the country. And like I mentioned, this means that there are repercussions in terms of commercial and legal aspects of these businesses. So it affected not only the supply chain, like I said from the beginning, but all the way to actual employees. So now coming to our first topic, so real estate. Real estate in Cyprus has become one of the major industries that allowed it to become almost the second Dubai, if you like. The reason being is that construction companies have been very busy recently, trying to tailor to the demand of foreign investment, injecting a large amounts of money and trying to acquire the citizenship. So in terms of the law, EU residents, EU members, and CY, Cyprus, residents are freely allowed to purchase properties as they wish. But in terms of foreigners, there's a restriction in place according to the law that they can purchase one piece of land or residential property, but it can't be larger than a certain amount of size. So it can't be anything. It has to be specific to the criteria, to the specific law. So that meant there was a little specific hurdle for foreign investors. So if someone wanted to basically utilize and take advantage of this booming industry, it would be advisable for anyone to, put a certain amount and actually get a citizenship and be able to do as any other EU member citizen. So the reason why the president introduced this scheme is to basically attract foreign investment and help at the time, it was a really suffering economy after the 2013 haircut crisis. So it was really interesting that in a short amount of period of time, Cyprus was able to bounce back really quickly. And we have seen through that scheme, it's called the Naturalization of Investors in Cyprus by Exception scheme. And we have seen a huge influx of foreign investors, especially from Cyprus, from Russia and from China. And understanding that process is understanding the legal effects of each of the parties. You have to understand that depending on which side of the spectrum you are, who you are, if you're the investor or the developer or the seller or the buyer, depending on where you are and at which stage of the process you are in, you will need to look at your legal rights. You'll have to discuss with a lawyer. Either you have a contract signed, or if you don't have a contract signed, it's really important to understand your rights and your obligations to avoid breach and to secure your interests. So in terms of the conditions for this scheme, it's really interesting, actually. You would have to invest about 2.150 million, so 2,150,000 euros minimum. And you become an EU citizen in about 180 days, so that's about 6 months. And you have to retain your investment for 5 years. After 5 years, there's an option of you getting back your investment. And the amount of the investment that you can retain is the 2 million minimum. There's a couple of conditions. So the applicant must have a clean criminal record. They cannot have their names listed in one of the EU lists of frozen assets, so they can't have any frozen assets, so they can't have any criminal implications in other countries. They have to have a valid Schengen visa, and at the same time, they have to have a permanent residency 6 months prior to the actual application. And in terms of the residential property, I'll get to what you need to do if you are interested in this investment scheme, is that you actually have to retain one residential property worth minimum 500,000 euros, plus VAT. You have to consider VAT as well. So the benefits of this scheme is that not only do you get a fast-track citizenship, you get visa-free travel to over 150 countries worldwide. You get to live, work, and study in the European Union. You get citizenship for your entire family. If you wish to get citizenship for your parents, the parents basically of the applicant, then they would have to acquire an extra residential property minimum worth 500,000 euros. So keep that in mind. And like I said earlier, your investment can be returned after 5 years, so your 2 million investment minimum. Like I also said earlier, it's a very attractive tax regime because taxes are really low. So it can be as low as 20%. And you get access, your children, if you're an applicant with children, you get access to Cyprus and EU education systems. Either you get discounts or even free education, depending which university your children will be wishing to apply to. And the thing is, you don't require any language or any historical test, so you don't need to actually learn the Greek language, so you can just quickly apply, and it's a much easier process. And you're able to retain your other citizenship if you have a dual citizenship. So any applicant wishing to engage into this scheme will be able to choose from a large portfolio, real estate portfolio. Like I said, if you just go on Google or even YouTube and you just type in Cyprus real estate, you'll understand. Even me, as a person who's been living in Cyprus for many years, I have seen it grow into a very different country. It's like we have high towers now. We never used to have such huge buildings. We have huge buildings now. We have the marina being built. We have the casino being built. We have a lot of things that accommodate to foreign citizens and as well as the newly acquired citizens of the Cypriot passport. So like I said, the criteria for the passport investment scheme from 2020, so from now, recently, like I said, the applicant will either have to buy a 500,000 euro residential property. They cannot sell that property. It has to be with them for life. They can rent it out. That's not a problem. And additionally, you would have to pay about 150,000 for innovation. So 75,000 to the Research and Innovation Fund and 75,000 to the Cyprus Land Development Corporation. So that'd be like a donation that you wouldn't get back. And you have 4 options. So one of the options is where do you inject your actual investment, your 2 million minimum investment. So if you wish to invest in commercial real estate, property, construction, development, you'd have to have approximately minimum of 2 million. The second option is alternative investment fund. So securities, bonds, etc. So that would be the second option. The minimum amount will have to be 2 million euros. So the third option is also investing 2 million minimum in Cyprus-based businesses that have to have demonstrated an existence and a presence in Cyprus. And the fourth option is a combination of the above, but the combination of the amount combined has to be minimum of 2 million. So in terms of the process, so there has been an amendment. Previously, various agent companies started rushing and taking this opportunity and applying on behalf of foreign applicants for this scheme. But then the government had to had to change a bit of the rules in order to be in compliance with EU regulation. So now, if you do this application, you have to go to someone who's registered, and they have to be a registered entity with the Registry of Service Providers here in Cyprus. It's really important to know that. The second thing I would advise someone is speak to a lawyer. I have to say this so many times. People just don't realize how important it is. It's the lawyer who's going to check your contract. It's the lawyer who's going to know the local laws, and you'll understand in a bit why it's very important for someone wishing to invest in Cyprus to know the local laws. Because according to whether you are an investor, a developer, or wishing to be a landlord in the future and renting out those properties that you purchase, you need to understand the differentiations between the different sectors of the law, okay, and the areas of the law. So engage with a law firm. And if everything goes well, you can acquire the citizenship within a 6-month to 8-month period. You'd have to pick the property. You can sell someone you trust to choose from this large, vast array of real estate portfolio. But you'd have to visit Cyprus only one time for your biometrics. So that's the only required visit. If you want to visit twice, it's up to you how many times you want to visit, but at least a minimum of 1 visit. And like I mentioned earlier, you need to have acquired 6 months prior to application. You need to have a permanent residency for 6 months. You'd also have to be aware of the costs. Putting aside the 2,150,000 minimum investment, you'd also have to be aware of government fees. So it could cost for each applicant about 7,000 euros. So you'd have to be aware of that. And any agency that is registered will inform you of the fees accordingly. Now, in terms of the COVID-19 effects on the real estate investment, I'd have to put in light, and I have to stress again, that we have had a huge influx of especially Russian and Chinese investors. We've even had Lebanese investors, Arab investors, Egyptian investors, everyone coming here, flocking here to Cyprus to take advantage of the scheme, because you get an EU citizenship, and that means you get advantages of all the benefits that an EU citizen would have. You'd be naturalized as if you were already a Cypriot citizen, an EU citizen. So in terms of property purchases, it has become in excess of 6 billion euros by mostly Russian and Chinese investors. And that has actually helped the economy recover after the almost meltdown that we suffered in 2013. However, with the travel bans, like I mentioned earlier, there's a lot of legal implications that someone would need to be aware of. Not just a businessman, just anybody who's even a normal tenant or a normal landlord who has just one property and they're renting it out, or someone who's pushing a new couple and they're investing their savings on purchasing a new residential property. People need to understand the local laws, and they need to understand the contractual implications of such. I would advise anyone not to be stingy, sorry for that word, with getting legal advice. It's really important. I always tell people, if you catch a lawyer from the beginning, you will save yourself a lot of time, hassle, and money. And furthermore, if you are yet to enter into a contract, please take into account the pandemic. You need to make sure that you have the appropriate clauses in order to address your situation when the time comes that you have a proper redress. So the government estimated that we lost about 1.5 billion euros from the tourism sector because of the COVID-19. So you can understand that it's not just in terms of money. If you think, a lot of people need money to survive. So if you think of all those jobs affected, all those hoteliers and all those employees working in hotels and all of those employees that were dependent on foreign investment, tourist agencies, all those people in the chain have been affected. And although the president, the day before yesterday, announced that we would have a 4-stage lifting of those bans, okay, if everything goes well, by July, everything should be going to normal. I don't know how, I can't predict, but we'll see how things will go. It's really sad, because a lot of people have had to see either losing their jobs because of these measures. A lot of businesses have to shut down. And a lot of these construction companies and developers have had to suffer basically a stagnant period of time where, things were very uncertain on how things will, proceed from there. So why do I want to go into property law? It's really important to understand that if a foreign investor, if you're wishing to invest into Cyprus and acquire property, and your intention is actually to acquire various properties and rent them out, or even sell them to someone else, etc. If you are wishing to be a landlord, or even if you are a business company and you want to rent from the market, so depending on which side of the equation you are in, you would need to be aware of the property law, the local laws here in Cyprus, because they're not as simple as people think they are. And a lot of people, even in Cyprus, don't understand the difference between the two types of tenancies. So essentially in Cyprus, we have two different types of tenancies. So we have the contractual tenancy, and then we have the statutory tenancy. And it's quite self-explanatory from the name itself. So let's start with the contractual tenancy. Contractual tenancies are basically governed by contract law. And if you have any dispute, it's basically adjudicated by the district court in Cyprus. Whereas a statutory tenancy is governed by the 1983 rental law, and basically what it does is basically protects this type of tenancies. And the reason why it was introduced, and the reason why a lot of you are thinking, well, that's really weird, what is a statutory tenancy and why is there a need to even distinguish the two? Well, after the aftermath of the invasion, of Turkish invasion here in Cyprus, we have seen a lot of influx of refugees from the north coming to the south, and the government, in effect, wanted to protect those refugees from spiking rent prices. So they placed this law in order to control the amount of rent a landlord within that ambit, the rent increase, so they can increase the rent as they wish, and in terms of eviction. So on what grounds can you evict a statutory tenant? So essentially the rent law, the 1983, I'll call it the 1983 law, it's tilted towards the scales in favor of the tenant. But we shall see in a bit that in the beginning of this year, the parliament introduced amendments to the law in order to bring the scales a little bit of a balance. So allow landlords to be able to evict tenants quicker. So a lot of my friends here probably thinking, what do you mean by quicker? Well, in Cyprus, cases can be judged and trials can take as long as 2, 3, maybe sometimes 5 years. I know a case that's lasting 10 years in Cyprus, in the district court. So it's an issue. The Ministry of Justice and the President and the Cyprus Bar Association, they're all bodies that are trying to find a way to decongest the courts. It's a really huge issue. But if someone who's a landlord or a tenant, they need to be aware of the pros and cons of being a statutory tenant or a contractual one. And I'll discuss the pros and cons in a bit. So in order to assess the jurisdiction, you need to first assess the particulars of each case, the characteristics of the immovable property, and we need to assess if it's a contractual tenancy or a statutory tenancy. Because a contractual tenancy, it has a little bit more leeway. It's governed basically by contract law, so the freedom to enter a contract and agree the terms that you wish. Whereas a statutory tenancy, the agreements are subject to the 1983 law. So going to the statutory tenancy, I hope, guys, I'm not boring you, but it's really important to understand the differences. If you're a serious business, or even if you're just a normal landlord or a tenant who has one property, it's really important to understand the difference. I've had clients come up to me and ask me, oh, Amani, how are we supposed to proceed from here? I have a tenant who's, not left my house and they're not paying rent for 5 months. What am I supposed to do? I have to go into the law and find out whether their property, their immovable property, is governed by the 1983 law or whether it's governed by contract law. And given that at the time there was no contract, you can imagine how difficult things were. So luckily, with negotiations and with a little bit of, legal pressure, we were able to solve the problem much quicker than expected. Had you gone to court, especially district court, for contractual tenancies, like I said, it can take years to solve a dispute. Please remember this. It's really important. It's important to understand that here we don't have cases getting judged as quickly as you think. So if you can negotiate, and if in terms of now what's happening with coronavirus, and in whichever end of the legal case you are in, or whichever point in the course of action you are in, you need to understand that negotiation is power. If you're able to negotiate with the other side and avoid the hassle of the courts and the cost and expenses of the court, it's much better for you. It's much more business for us as lawyers to have cases in court, but the type of lawyer that I am is that I try to run an ethical business, is that I try to get my clients the best deal possible. And you have to understand your own rights, and you have to understand that the best deal possible for you is to try to negotiate. Don't just think, oh, I'm going to go to court. Think, how can I solve this issue with the cards that I have? So your contract, your bargaining position, who's at fault, are you the one trying to rely on the contract, etc. and etc. So it depends on every different case and its merits. So now, going to the 1983 law, the conditions are that if you are to be protected by this law, you'd have to have an immovable property. It can be residential or commercial, okay? It has to be within this is the key determining term. It has to be in the controlled area. What do I mean by that? Controlled area is a specific area declared time to time by the Council of Ministers that this area is a controlled area. So you have to abide by the 1983 law. So how do you find out if your property is within the controlled area? Either you get a lawyer to find it out for you, because it's very difficult to research this on your own, because it's, first of all, if you don't know the Greek language, difficult. And the second, it's very difficult if you don't understand in general how to find this type of information, because even me when I was a newly qualified lawyer, when I was researching for whether a specific immovable property was within the controlled area, I had to go through hurdles. So what I'm giving you now is very helpful information, okay? And thank you everyone for your comments. So the other condition is that the immovable property has to be built before the 31st of December, 1999. So these are the main conditions, okay? And the persons wishing to rely on the protection of the 1983 law, they need to understand this very important piece of information. You have to be a Cypriot citizen or an EU resident. So your residency would have to be in Cyprus. This is really a very important factor. And The other important thing that we need to mention is that even though it fits all these criteria, and we say, okay, it's a statutory tenancy, if it's less than 6 months, it counts as a contractual tenancy, and then it falls within the ambit of the contract law in Cyprus. So you need to understand all these details. You know, you can either write them down now or you can watch this video later, but it's really important that if you are within the real estate sector or even wishing to buy property or intending to rent property, you have to keep this in your mind. You have to pick which area is it better to rent from and which area is better to purchase from, because there's pros and cons for the landlord and the tenant. In terms of eviction, okay, pre-amendments, pre-January 2020 amendments, it took also years to evict a tenant, a statutory tenant. There were a lot of criticisms, there were a lot of voices being heard, people were complaining, this was completely unfair. Why should our landlord have to suffer years of unpaid rent, you know? And then the government, the parliament took that into consideration and they passed an amendment to the law allowing landlords to evict tenants within months. So it can take from 3 to 6 months or even 8 months, depending on each case. And the only way you can actually evict a statutory tenant in general, the only way you can really evict somebody is it has to be through the court. You have to get a court order. And it's, in light of the statutory tenancy, it's even more difficult. You cannot absolutely evict a statutory tenant for whatever reason. It has to be for the following reasons that I'm going to mention now. So either they omit to pay rent, either you give them a notice, okay, 21 days pass, and even after that 21 days, they still don't pay, then you can start the procedure. So after the 21 days, you file your application in the court. They have 14 days to file a defense, okay? If they file a defense under the new law, the burden of proof shifted. So now the tenant has to prove that they did in fact pay the rent. And that is a very important factor here. Guys, legally, everyone who knows the law, whoever has the burden of proof has the burden of proving the first step of the law. So here the tenant has to prove they actually paid. So the other reason for why you would evict a tenant, if the actual landlord owner wishes to use the property to live in for them and their family. And one of the other final reasons is if they want to demolish and to renovate the property. However, the court will take into account before evicting a tenant, if they do decide to evict a tenant, if the tenant has any requests for reasonable time to find suitable accommodation, so alternative accommodation. Okay, so the benefits. The benefits really, pre-amendments, it was very tilted towards the tenants' rights. So tenants who would, a lot of times, would either take advantage of the 1983 law, and a lot of people actually did have difficulties. So, you know, we'd have to understand the human factor behind that. A lot of people at the time after the war, a lot of refugees were coming into the south and they had difficulties. But in light of now, the government realized that it's not like post-war. A lot of time has passed. The economy developed. People are more likely to have suitable salaries to pay rent accordingly. So after the amendment, it's, you know, the scales have been sort of shifted into a little bit more imbalance, but we have yet to see the enforcement of this law. How will it be enforced? What will happen? Because once the amendment was introduced, we had the whole coronavirus thing happen. So in terms of all the other tenancies, so all other tenancies are contractual tenancies. They're governed by the contract laws here in Cyprus. And in turn, that means the jurisdiction is through the district court. Like I mentioned, it's one thing, the rent control tribunal, which you go through as statutory tenants, and that can take, now with the new law, about 8 months to evict a tenant. Or you can go through the district court, it's not up to you, it basically depends on the property. And that can take about 2-3 years, sometimes even 5, depending on each case. So that's why I advise people negotiate, make sure you have a bulletproof contract, because let's say the tenant causes you trouble, or the landlord, you know, even if we have to be fair here, we have to discuss both rights, the landlord rights and the tenant's rights. So let's say each one is being unfair or they're not acting in good faith. If you have a contract in place that protects your rights, at least when you do court to court and you do seek compensation for damages, at least you have something in writing rather than just, you know, trying to prove something that was said orally. I think that goes without saying. So the contractual tenancy is governed basically by duration clause. So a lot of tenancies have a duration, so either 1 or 2 years. Here's another tip for you guys. So I wouldn't advise renewal periods, because if you do renewal periods automatically, then you have to pay higher taxes. So just do your tenancy like 1 year or 2 years, and then subject to, you know, the pre-approval of the parties. You know, that's one tip I'll give you guys there. And in terms of the, let's say we have a tenancy that fits the criteria of a statutory tenancy. So it's an immovable property, residential commercial within the controlled area and built before the end of 1999, but it's less than 6 months, it falls within the contractual tenancies. Okay, like I mentioned earlier, there were a lot of criticism. So what happened was, in the beginning of this year, the government, the parliament, sorry, I keep saying government, but essentially, okay, it's parliament, introduced a new procedure. Like I mentioned, the procedure is much quicker, and it allows service electronically. So you can electronically serve notices, and it's basically modernizing the law, allowing aggrieved landlords to deal with non-paying tenants who either intentionally or fraudulently take advantage of this law. So there was a really huge loophole that the government tried to fill in and make it more fair for the other side of the, you know, spectrum. And the issue, though, it affects only a class of properties, so statutory tenancies. It doesn't affect the others. So we have to see in the future how things will go. Coming to our discussion, coronavirus. What did the government do in order to relieve people of the economic stress of not having to pay rent? A lot of people either lost their jobs or just didn't get that much salary as they would pre-COVID-19. So the government put in place an amendment to the actual to the 1983 law that landlords were not allowed to evict tenants during this time, and they were not allowed to try to get rents until the end of May, so 31st of May. So what it essentially does is that it postpones the eviction procedure. Okay, it postpones the eviction procedure and it bans banning evictions. Okay, so it bans evictions of statutory. We're talking about statutory tenancies here. Okay, please keep that in mind. But what that means is that it postpones payment of rent. That does not mean cancellation. And people understand that, you know, playing with words, one word can change the entire meaning. So what would I advise any kind of tenant, whether statutory or, you know, contractual, speak with your landlord, have a discussion with them, discuss with them in good faith, tell them, look, I'm going through a really difficult time. What can I do? You know, can I pay rent in half, or can you just, you know, forgive the rent this month, or can I pay you in installments? Depending on your landlord, you know, we'll see the outcome of your negotiations, but discuss. Don't just leave it till, you know, after the 31st of May, because you might end up having a claim for all those due amounts. So it's better just to get things out of the way from the beginning. And the thing is, this amendment does not cover rent due before the 1st of March. So you can't say, oh, I didn't pay rent pre-1st of March. It has to start from 1st of March until the 31st of May. That's the measures that we have for now. So what does that mean for tenant and landlord relationships when it comes to when it doesn't apply, when the 1983 law doesn't apply and the contract rules and regulations apply? Like I said, district court, it can take a couple of years. Tenants don't have the same protection, and basically the relationship is governed by the agreement and what the parties agreed to, essentially. So a lot of people, and I'll get to the argument of frustration and force majeure, the contractual implications of business relationships, and in general, any relationship with contractual, basically essence, is that a lot of tenants are saying, oh, can I not just pay, even though I'm not a statutory tenant, can I not just pay rent because I'm going through this difficult time? You have to understand, if you have an agreement, the whole point of agreement and the essence of a tenancy agreement is that you pay rent. That's like the alpha and the omega of the actual agreement. So you need to pay rent. Usually landlords don't care so much about the other details as much as them receiving the rent. And I will mention that again until, you know, repetition sometimes is very effective, so people understand that you need to discuss with your landlord. It's really, 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 really important that you discuss with your landlord. Do not be idle, do not be, you know, leaving things to last minute. It's really important to discuss from the beginning your rights and your obligations, okay? You can discuss a reduction, and there's a lot of techniques in terms of negotiation. So let's say you agree with the landlord orally, go afterwards, send an email or a message, say, as we agreed, you know. I'll be happy to answer any questions. People can either comment down below, or they can send their questions, and I'll be able, if I have time, either after the speech, or we'll get into direct conversation. We can arrange a consultation and discuss further. So let's get to contracts. Actually, funny enough, I stumbled into being an expert on contracts, not because it's something that I grew up and said, oh, I want to be an expert in contract law, I love contract law. It just happened because I really do actually enjoy contracts. I've been drafting contracts and reviewing contracts for many years. Even before becoming a qualified advocate here in Cyprus, it's something that I really enjoy doing, and I try to help people as much as I can by giving tips. So I always say that piece of paper, that contract that you sign, by your signature, you give a power that it never had. It's like money. Money before being printed as money, it's powerless. As soon as it's printed as money, it has a lot of power. So please fathom that concept. The concept that a contract becomes powerful with your signature. That's really, really, really important. So before you sign, first, okay, speak to a lawyer, have them draft a contract, disclose all the relevant information to them, think of any scenarios you would want included, okay? So now let's get into the topic of today. I need to mention that there's an undeniable worldwide impact of human tragedy with regards to COVID-19, okay? But at the same time, we have an economic impact. And if we have a bad economy, it means unhappy people. There's like a ripple effect. If people lose their jobs or don't have salaries or have food or have money to actually eat, then that in turn it affects the human situation. So if you have a good economy, you have generally happy people, okay? So with the exponential spreading of the virus, the governments in Cyprus and worldwide have put in place and implemented containment measures to try to contain the virus. And with those measures, it had a knock-on effect on businesses, all the way from the supply chain and to the employees. And given that I mentioned earlier that the real estate and the tourism sector in Cyprus is very, very prominent here in Cyprus, I cannot even stress this anymore. A lot of people, have the bread and butter from these sectors. So it has a severe impact on tourism, COVID-19. And consequently, hotels have been closed. Employees had to stay home, get reduced salaries. A lot of people lost their jobs. And this unnervousness and uncertainty with regard to the current situation rippled the entire economy. So people right now just feel confused. They don't know what's going on. I don't know if we ever passed such a situation, because actually we didn't during our time. We did go through wars and everything. We did go through recessions. Like personally, we came, in Cyprus, we had the 2013 recession, but health issue such as we call the invisible enemy, like coronavirus, you go outside, you don't even know where to go and what to do. Like anything you touch, you basically hand sanitize and wash your hands. It's basically changed the whole structure and format of not just business relationships but human relationships and how people cooperate together. So what I want to talk about in terms of contractual implications is that from a contractual point of view, it's really important to know whether you have a contract, existing contract, or whether you're going to enter into a contract, okay? And the general principle on contract law is that if you agree on something, so if you have an agreement and you agree on certain rights and obligations, the general rule is that you have to perform them. You have to execute the contract. There are exceptions, however, when unforeseeable events affect that foundation of the contract and may justify in certain circumstances the impact to be taken into account. So that's the general principle and exception. A lot of people may have heard of force majeure clauses. And force majeure clauses is not just in shipping context. It can apply to various contractual agreements. So force majeure is it's French and it means superior force. And in Cyprus, it can be used as a discretionary clause. And generally speaking, it means it describes many factual circumstances or events that occur and go beyond the control of the parties and justifies either the non-execution, so not executing the contract, or delay in performing the contract, okay, depending on the wording of the actual force majeure clause. So the purpose is to basically release the party from any liability. So you understand, if you in contract law, the principle, the essence is this: if you don't perform your obligation, you can be in breach. And breach means what? Compensation and damages. So you don't want to be in breach. So like I said, negotiations, don't forget that. So it really depends on the actual contract. And sometimes a lot of contracts incorporate a general clause. So they'll write force majeure. The obligations of the party can be, for example, suspended, delayed, postponed, whatever. If an event, a superseding event, basically causes goes beyond the control of the party and causes the parties to not be able to perform the obligations or whatever they agreed on. The court will interpret the clause accordingly, depending on the contract, depending on the nature of the business, the purpose, the intentions parties at the time of the signing. That's really important. But generally, the burden of proof, okay, so the person who wishes to rely on the force majeure clause needs to argue the following. They must prove that they made every logical effort and taken every reasonable step to mitigate the situation or the event. And there was no other course of action that could have succeeded. It's really important to understand that. So let's say, for example, we have a restrictive measure introduced by the government, and they're unable, for example, due to the rules, they're not unable to deliver something. But if the restrictive measure is going to be lifted in a week's time, that doesn't justify termination of the contract. What it might justify is a postponement. Like I said, it depends on the facts of each case, and it's very important that people fathom the concept of negotiations. Don't just go, oh, I'm going to go to court and sue. Negotiate, be reasonable, and have good faith. A lot of business relationships will be saved if people just acted properly. Properly, I mean in terms of trying to find a solution. So, the second part of this discussion. Can COVID-19 be considered as force majeure? I know that all across the internet, fellow lawyers, fellow solicitors, barristers, everyone around the world discussing, oh, is coronavirus a qualifying event to be considered as a force majeure? I'm going to discuss Cyprus. Okay, I'm going to discuss Cyprus and what would be of concern here, because that's why you came here to listen to, Cyprus law. In light of the fact that the World Health Organization declared COVID-19 as a pandemic in the beginning of March, and then the President of the Republic in the mid or towards the end of March enforced basically restrictive measures in the entire country, entire island, we need to nevertheless do a very careful assessment of how likely and to what extent is COVID-19 a force majeure event. And what we're considering today is private contracts. Private contracts meaning contract entered between private entities, companies, persons, etc. So the factors will depend on the following: the precise language, the construction of the clause, what was written, the very nature and the subject matter of the contractual relationship. So in our today's subject is property construction. So if I were to, for example, have an investor, approach me, or developer, and they're saying, developer, what am I supposed to do? My workers are not working. The government imposed, these bans. What am I supposed to do? I have a deadline. I will tell them, I need to read your contract. I need to know what you agreed with the investor. I need to know what happened exactly so I can advise you accordingly. And I'll always try to basically build a case, try to find a way to mitigate their loss, try to negotiate, try to avoid them being in breach. That's really important to avoid being in breach. And the thing is that whether force majeure qualifies as coronavirus qualifies as a force majeure event, it really varies from jurisdiction to jurisdiction. So it depends on the law. Like I know in the civil jurisdictions, our fellow colleague on day one, shout out to Dr. I forgot his name, but he did mention that in Thailand, they have an actual definition of force majeure. I'll compare that to Cyprus, where we do not actually. It's a common law-based system, and we don't actually have a statute definition of a force majeure. So we predominantly rely on case law, and we allude to the common law cases of, for example, England. So even if a pandemic and an epidemic or a pandemic or whatever is mentioned in the contract, we'd have to look at the facts of the case. So people thinking, oh, because COVID-19, it's a pandemic, you're quickly running to justify that, oh, I'm not going to perform the contract. It depends. It depends whether you will justify delaying your performance or whether it justifies full termination, so canceling the contract completely. It depends on a lot of things. So like I said, it depends on the construction of the clause, etc., etc. So we have a test. Whether if it's a force majeure event, we have to make sure that the event goes beyond the reasonable control of the affected parties, and the parties' ability to perform their obligations under the contract must have been prevented by that event, so COVID-19, or in the ripple effect of COVID-19. And the third is the affected party must have taken all reasonable steps to avoid or mitigate the consequences of non-performance, and that they have to prove there were no alternative means of performing the contract. So make sure that force majeure is included in the contract. If it's for your benefit, included into the contract. It needs to have clarity. The more clear a contract clause is, the much better its implications by the application by the court. And there has to be a causal link between that superseding event, okay, and the party's inability to perform their obligation. It's really important to understand there has to be a link. It's called a legal term, causal link. So the consequences. So if, for example, it's ruled that that superseding event does qualify as force majeure, so the COVID-19 really did affect your obligations, there might be a delay in performance. There might be well, depending on the contract, depending on many things, it might be able to actually terminate the contract, or maybe get an extension of time. So it really depends on the particulars of each case. So we can't really judge and say a black and white answer. It really depends, a lot of gray areas. And essentially what that does is that if the party is able to prove that there were no alternative means and that were really affected, it prevents them from being liable for a breach. So like I said, negotiate with the other side, try to find a leeway and try to find a solution. Because you can all understand that it affected the whole world. It really did affect the whole world. And in terms of notice, make sure that in your contract you have a notification period. So if something goes south, there's a clause in the contract that say as soon as the party realizes that their obligations, the procedure of performing their obligations has been tethered with, that there's a notification period that they have to notify you as soon as possible. Okay, that's really important. So if the party is dissatisfied, they can still sue. They can still go to court and claim that the other party was in breach of the contract for not performing their obligation. The court will look at the following factors: the circumstances relating to the force majeure event, based on the specifics of each case, the factual events, the governing law, so Cyprus law, interpretation of the contract, parties' intentions, like I mentioned, and whether the party wishing to invoke the force majeure clause took all reasonable steps to mitigate its loss and try to find alternative means of performing the obligations. And just be aware that any fraudulent or unjustified invocation of the actual force majeure clause will lead to a breach, and that means the victim party will be able to request damages. So it's really important to have a lawyer draft the contract properly. So let's go to frustration. So let's say that the existing contract does not mention force majeure here in Cyprus. I'm talking about Cyprus law. So let's say the existing contract does not mention force majeure, and there's no other clause in the contract that you can rely upon in order to alleviate you from performing your obligation. Here in Cyprus, Section 56 of the contract law, we have something called frustration. And I know a lot of my fellow common law lawyers will understand what I mean. So frustration, it's a kind of self-explanatory. It means that it's been frustrated. The contract has been frustrated to such an extent that it could no longer be performed. It has a higher threshold, and its interpretation is much narrower, much stricter by the courts. So it's really difficult to prove. So I would advise anyone, don't leave things to chance. If you feel like something could bother with your course of action, include it into the contract. But one of the conditions of trying to use the doctrine of frustration is that there shouldn't be a clause in the contract superseding it. So if the parties agree otherwise, what the parties agreed to will take precedence. So it's really important to understand that. So Section 56 of the contract law basically says that a contract will be deemed automatically invalid, okay, if and when it becomes illegal or otherwise impossible to perform the contract. It has to be an unforeseeable event. It cannot be a probable event. It has to be an unforeseeable event. So it doesn't apply to just merely, undesirable commercial contracts or becomes physically or commercially impossible. It has to be that the obligation to perform it is so radically different from that which the parties initially had undertaken. So it has to be unexpected event that occurs. It has to be something that the parties could not have foreseen, and rendering the performance either illegal or impossible. And that would in effect automatically render the contract as invalid. So the court, when interpreting such contracts, will check the verbal and grammatical wording of the agreement. If you do wish to include a force majeure clause, then go ahead. It's much better to actually have a clause in the agreement basically governing the relationship, the business relationship. So the court will look at the general commercial purpose, the nature, the extent of the frustrating event, and the elements for the actual application of the doctrine are the following. So you need to have a valid agreement. The event has to be unforeseen, and that unforeseen event is not caused by the parties, and the event arose after they entered into the agreement, and the agreement had not yet been fully performed, and that further performance of the agreement is either illegal or impossible, and that agreement does not contain any other clause expressed or implied in relation to which the parties wish to rely on. And it's really important to mention here that, for example, let's say you agree something and then 2 months down the line, a government passes Parliament passes a law saying that it's illegal to do such action. That means your contract is frustrated. If your obligation has this event has caused your contract to be frustrated, in meaning that you're no longer able to perform your obligation, and the consequences of that is that automatic invalidation of the contract, termination. So it just stops there. But according to Section 65 of the contract law, any money paid or any consideration given, the party who has benefited from it needs to restore it to the other side. So there can't be any unjust enrichment. So given that the contract will be terminated, if you can't give back the money, and let's say you have to give compensation accordingly, so it have to be restored. So can the coronavirus, COVID-19, be deemed as an event leading to a frustration of a contract? Well, like I said, there's no clear answer. It depends on many things. It depends on the measures. It depends on the specific measures that are being introduced by the government. How affected were you by those measures? And it also depends if the contract was entered into pre-pandemic, pre-actual knowledge of the pandemic, or post. That means that if you had a valid understanding of the situation, then you should have been able to understand that your obligations will be sort of affected by the event. So it's really important to understand there's gray areas. It's not just like automatically because of coronavirus that the contract is frustrated. It has to be impossible, it has to be illegal, and the event cannot be probable, like I mentioned earlier. It has to be unforeseeable event. If the party is unhappy, they can still sue. They can still go to court. Like I mentioned earlier, the threshold is really high. The court are quite strict and narrow in their interpretation of such such clauses and frustration in general. And they will duly assess the circumstances and the facts of the case in line with the terms of that actual contract that also exists. So, bringing our discussion towards the end. I really love talking to you guys. I really enjoy talking. So I want to just mention a little bit things of things to consider, practical sides, things that can help you. I understand a lot of people don't have either access to lawyers, or a lot of people have a fear of lawyers, and this is really unjustified. A lot of lawyers are actually willing to help, just give you some tips and what to look out for. And another thing, if you hear a lawyer talking for free, write down, because there's probably a reason why they're trying to explain to you your rights, because that means it's really important and something current, and it will be really helpful to you. So let's get into the actual things that you must consider. Do not be idle. Do not sit down and wait for things to take its course. You need to take positive action into your cases. So whether you are a seller, buyer, property investor, property developer, whatever side of the chain you are in, you need to take action. So you need to check your contract. Okay, if you don't have a contract, or if let's say you do have a contract and you want to amend it to reflect the current events, you can have an addendum. An addendum is basically an extension of the contract. So you can have addendum either amending the original contract or adding an extra clause to the contract. That'll be something you can also delve into. So do your due diligence, depending on what you are. Try to mitigate your loss as much as you can. Discuss with the other side. Also, insurance. A lot of people forget about that. Revisit your insurance. If you don't have insurance, I would suggest, speak with the insurance company. They might be happy to help. You never know. You never know unless you ask. And discuss with lawyers. A lot of people might not be happy with this tip, but it's really one of the most important tips. Lawyers are lawyers because they're here, their job is to protect your interest and to help you negotiate properly your interest. I'm not advertising lawyers. Believe me, this is further from what my intention is. My intention is to basically inform you of your rights and to understand that, you know, it takes lawyers years and years to reach the position to advise you on a specific situation. You know, don't try to play lawyer because, you know, it takes tests, exams, and a lot of time for someone to be able to advise you on your legal rights. So try to find somebody within your budget or somebody who is within the expertise of law that you require and get their advice. It's really important. So the recommended actions I would basically offer you guys to do is if you have executed a contract, please read it carefully. Again, have a lawyer read it carefully. If you feel like things are going to get more complicated, understand which side of the contract you are in, whether you are the seller, the buyer, the property developer, investor. Again, I'm repeating myself, but I have to repeat because I have to explain the context of the conversation today. Maybe you're a construction worker, maybe you're the owner of the business of a construction and you have issues pertaining to that. And if you're considering entering into a new contract, like I previously mentioned, make sure you take into account the coronavirus, because we don't know how long it's going to stay for. We don't know how long the vaccines are going to come in. And in terms of breach of contract, you have to understand whether you are the aggrieved party wishing to rely on seeking compensation damages for the contract. You need to understand the under common law, because we have a common law system here, that the loss is limited to that which is within the ordinary course of things, and that the actual that it can be remote. So the link between the event and the loss suffered, it can be remote. So it can be two different kind of things. There has to be a causal link again. So beyond damages, if someone promised you something orally or something, have it incorporate into the agreement, have it in writing, write them an email. Just generally be careful. Also be careful of time of the essence clauses, because sometimes in the contracts people write time is of the essence. What does that mean? It's open to a lot of interpretation. Maybe the investor wants the project finished on a specific time and you're past that deadline, and they mention a time of the essence clause. So they want it finished within 6 months. They want the project finished within 6 months. So I would suggest that before the 6 months lapses, that you send them an email or even give them a call and discuss with them. But before you do so, please read the contract, okay? And sometimes people think that if they cannot rely on force majeure, they can't rely on frustration, that they don't have any line of defense. It doesn't work like that. You have to read the contract. You have to check, the lawyer have to check the law for you. It depends on the particulars of each case. So I would suggest don't give up, keep going, and try to find the best solution for your case. It's also good, we have Google, our predecessors didn't have Google. I actually learned the language just by using Google Translate. So if a lot of you can understand the power of the internet search engine, you'll be able to just enter what your question is and get a lot of information before actually visiting a lawyer. So you can have some form of basis of knowledge of what you're trying to acquire. So practical steps. Keep records, have evidence. It's really good that if you have evidence, that when you go to court, it's easier to prove your side of the case. Like I mentioned earlier, insurance, it's really important. Talk with your insurance company. Also take preventative measures. If there's a way that you could have mitigated your loss and that could be proven in court, but you didn't take those preventive measures, then that goes against you. So you need to also consider that. Also, please speak with a professional, if it's in terms of, let's say, construction. Talk to the professionals handling the project, see what can be done. There's a lot of things that, that can be discussed. And in terms of the property investment scheme that I mentioned earlier, that, a lot of foreigners are injecting a certain amount of investment to acquire the citizenship, the government actually is really excited to accelerate the process of such, because that means further money into the economy, further booming of the economy. So, just keep an eye on the applications for the scheme. So to basically conclude, the situation is really unpredictable, and it will really all boil down to the development of the crisis and the pandemic. So the president before yesterday announced that from the 4th of May, there'll be a 4-stage process of lifting the countermeasures, so the restrictive measures. There's a lot of categories. With the time budget that I have, I can't discuss them all. But in terms of the tourist agencies, they'll be able to open on the 4th of May, so next week, and the construction sectors. That's good news. That's really good news for the economy. Just people wash your hands and use antiseptic. Just be careful and don't just touch everything and touch everyone. Follow the advice of health officials, and the World Health Organization always updates the people. If you follow them online, you can see they constantly advise you on the things that you can do and shouldn't do health-wise. So the president said that if everything goes well and everything goes planned, by June, July, there'll be a full lifting of the national lockdown and restrictive measures. So that'll be good news for, the airports will be able to open. We'll have tourism being able to revisit the country. That means, we'll be able to somewhat not just save the economy, but save the human aspect of the entire process that have been affected by this pandemic. So we have to see how those affected will be able to, argue all those above mentioned lines of defense. So whether you'll be able to invoke the force majeure clause, whether frustration, whether you have another material adverse clause in your contract that it's a lot of legal jargon which I do not want to get into. But what I say, which is a famous phrase that all lawyers say, it depends. So it really depends on your case. It depends on the law. It depends on your lawyer. It depends how your lawyer argues your case. It depends on a lot of things, But clients have this misconception that they can just sit down and rely 100% on the lawyer doing the job. You also need to act. You need to act by acting on time. And before we actually finish, because I'm done with my speech, and I know we're a little overboard with the time, but I really wanted to get my points across because I think it's very useful to a lot of people, not just nationally, but internationally, if anyone is wishing to engage with the Cyprus economy. I want to also give just a piece of advice for aspiring lawyers and law students. It's really important not to just speak and to show off that you know a lot of legal words. Even during court, I have seen established, experienced lawyers who have lost the attention of the judge because they were just saying things just to show that they were, expressing difficult words. And it's really a matter of, how to grab the attention of your audience and how to grab the attention of even writing an essay. You need to be precise, to the point, simple, and just, you need to show that, yes, you need to show you have a good command of the language, but at the same time, people need to understand what you're saying. So this is a tip I want to give to all the aspiring lawyers and law students who are here tuned in today watching the video or who will watch the video later on. And as for the general public, that piece of advice that I would like to give you all is just don't be scared to speak to lawyers. We do not bite. We're actually here, with the mission to help you protect your rights. Find the person that is, is compatible with your with what you feel and the mode of cooperation that you would like to happen in the future. So I have a couple of questions. I don't know if we passed the time. Let me just check. Sorry, one second, I'm just checking the questions. What returns can we expect on property investment in Cyprus post-pandemic? Like I said, we don't really know what's going to happen. But what I can tell you is from the criteria is that if you pay, for example, if you invest 2 million minimum euros, after 5 years, you'll be able to get it. Now, what's going to happen if, let's say, the things get worse? Because supposedly things are getting better. If things get worse, I don't know if the government will introduce amendments the parliament or even the government will introduce amendments to the scheme. But as things are going, things are still the way they are, like I mentioned. So you'll get your return on your investment after 5 years. Just remember that you have to do your investment 3 years prior to the application. So you cannot have invested in Cyprus 10 years before and then apply for the application. So just be careful of those deadlines. The benefits of making investment in Cyprus, it's a lot of benefits, honestly. I'm actually originally of Arab descent, so I'm not, so I'm Arab Cypriot. My parents have migrated to Cyprus in the 90s, and we've been here ever since. Not for me personally, I love living here. It's not just because of the weather and the food and everything, but in general, it's much safer and it's much easier to live here. Taxes are low. If you are a young person, you want to start up a company, it's really beneficial. In Cyprus, you have low taxes and the cooperation of an actual company can cost you as little as €1,000, excluding the cost, the other fees and costs. It may cost you around 1,500, and don't forget the annual levies, etc., etc. But in general, it's not that expensive if you want to start. And here, you're not just a number. It's 900,000 people in the island. So if you want to make a name for yourself, or if you just don't want to make a name, if you just want to relax, you can just buy a property up in Troodos, which is high in the mountains, and live a peaceful life. So thank you for that question. Apart from real estate, is there scope for technology companies start? Yes. Innovate, like I mentioned, one of the criteria of investing in property in Cyprus is donating 75,000 euros to any department of innovation. So that means that the government and in general the parliament is taking serious serious considerations into innovation. They understand that technology is the way forward. It's very important. I know we do not compete with our counterparts around the world, but Cyprus, don't forget, it's an island and it's developed very quickly. Like, I challenge you to go online and just write Cyprus real estate, and in general, you will see that it's developed a lot. We have a very highly skilled and educated population. A lot of the people go abroad and study, or even we have really good local university here, University of Cyprus. It's very advanced as well. So in terms of scope for technology for companies, yes, we have a lot of startups and we have a lot of technological companies actually moving here to Cyprus to set up their business and take advantage of all those incentives that I've mentioned. So what is appropriate legal fees? Okay, appropriate legal fees. Moment of silence. Okay, so appropriate legal fees, it really depends. Again, it depends. I'm sorry, I keep saying it depends, but it's the answer I'm going to give to every question that it depends on the lawyer, depends on their experience. If you're talking about incorporation of a company, the minimum a lawyer will charge, for example, is 1,000 euros. But you can go to another lawyer and they'll charge you 2,000 euros because they have a huge, a law firm and they have 50 employees. So it depends. It depends which type of lawyer you go to. A lot of lawyers, either you also have corporate services. You have companies who offer corporate services. I always suggest people go to lawyers because people need to understand. You need to be aware of the local laws in general. Whichever country you go to, you need to be aware of the laws. So it depends. Appropriate legal fees, and depends on what case you're talking about. You're talking about a civil case, a criminal case, a property case. If you're talking about a drafting of a contract, it depends if it's a 5-page contract, if it's a 20-page contract. So the question needs to be a little bit more specific so I can, assist better, but it depends. Okay, are there any other questions? Thank you to everybody. Thank you to everyone who has, watched all the way through the live. And I want to thank anyone who survives the entire video if they did not watch it live. Thank you so much for your attention. I hope I made it as interesting as possible. Like I said, please remember those tips. And yes, so thank you and bye-bye.